Good evening again, dear colleagues, dear students. Thanks for joining us today, despite this busy end of semester, super busy, I would say. Today we will have our last GSPP webinar this semester, which is on a very, very important topic, I think, which is domestic violence. And if you have been following the kind of recent trends in Kazakhstan, there have been lots of discussions about domestic violence. There have been several major developments in recent years in this sphere. And then every kind of month or every week, there are hot discussions in society, especially if you follow social media, if you follow kind of the discussions in society. So this is a very, very important, at the same time, very, very kind of a hot topic in our society. And today we are joined by Dr. Khalida Azhigulova, who agreed to speak on this topic and brief us about this recent trends on domestic violence. Khalida, thanks again for joining us today. In particular, Khalida will talk about this debate about decriminalization, criminalization of domestic violence in Kazakhstan. So I would like to briefly introduce Dr. Azhigulova. She's trained lawyer. She holds a PhD in law from Leicester University in UK. She's now involved in many kinds of social activities, including international law, human rights. She is also a national coordinator of the Street Law Legal Education Project for school children, which is, I think, a great initiative by Khalida. She is also a certified UN trainer and a member of different parliamentary working groups on different issues, including elections, science, charity volunteering, and protection from domestic violence. Again, thanks, Khalida, for your time today. I think we should kind of proceed as usual. So Khalida will present for 25, almost 30 minutes about this topic, and she'll share her visions about this topic, and then we're going to have Q&A session. So in the meantime, if you have any questions, you can leave your questions in the chat function below, or you can leave them for the Q&A session. And for those who are not speaking, just a kind reminder, please unmute your kind of microphones if you're not speaking, because we may have some background noise. Okay, thanks, Khalida. The floor is yours. You have about 25 or 30 minutes.
Thank you very much, dear Janibek, for inviting me. It is indeed an honor for me to be here today, and thank you very much for everyone who found time to join our talk today. Indeed, this topic is quite important, and today we mark the last day of the global campaign of 16 days of activism against gender violence, which started on the 25th of November. And today we also celebrate the World Human Rights Day, and the day when the Universal Declaration of Human Rights was signed back in 1948. So indeed, it is a privilege for me to be here and talk about human rights and the ways to prevent domestic violence, because as we all know, domestic violence is a big issue, and it is a type of violation of human rights to dignity, to personal dignity. So let me start my presentation, and we will discuss today the main debate, one of the debates around the domestic violence cases. Just a second. So the topic of my presentation is domestic violence in Kazakhstan, criminalization versus decriminalization debate. And what we will talk about today. First of all, I will give you some background information about legislation and the changes in the legislation, how decriminalization of domestic violence happened. Then I'll present arguments for decriminalization, arguments for criminalization, and eventually I will leave you with a few points for further discussion, because as I understand, many of us here are researchers or would be researchers, and I believe it is very important to discuss this debate also from the perspective of current and future research. So whenever we talk about domestic violence, we need to bear in mind that there are five main articles, and they were initially introduced in the first Criminal Code of Independent Kazakhstan back in 1997, And what are these articles? Again, I would like to mention that the articles I'm going to talk about, they are general articles. So domestic violence has never been separated. It was never shown like as a separate type of crime or criminal offense in our criminal code. So if you talk about the criminal code of 1997, it has Article 103, which contains which talks about grave harm to health and contains punishment for this type of crime. And what it means is that the main criteria is that a survivor or a victim of this type of crime should have a permanent loss of 1/3 of ability to work. There is a danger to life. And initially, the punishment was either the restriction of freedom or imprisonment up to 7 years. Then we had Article 104, which established liability for moderate harm to health. And the criteria were long-term health disorder over 21 days, and substantial and serious loss, or not permanent, but serious loss of ability to work. And the punishment was restriction of freedom up to 3 years or imprisonment up to 2 years. Article 105 established liability for minor harm to health, and the main criterion was that there should be short-term health disorder under 21 days. And the punishment included either a fine, performance of community service, correction service, or arrest up to 3 months. And here I would like to show you the difference and actually draw your attention to this very important fact, to which we will refer a bit later today, the difference between the moderate harm to health and minor harm to health. And what does it mean? It means that whenever a victim of domestic violence sustains injuries, their gravity is assessed based on the number of days that a person is hospitalized, officially hospitalized. And a person must officially stay in a hospital for at least 21 days and above 21 days in order for this injury to be considered moderate harm to health. So it basically doesn't matter, whether a person sustained, breakage of ribs, head concussion, brain concussion, or maybe the breakage of jaw and arms, limbs, and so on. But if the person does not stay in the hospital for 21 days, then this injury will be considered as minor harm to health. So it is important for us to note for future discussion. Then we had Article 106, assault and battery. In Russian, it's called as poboi. And the main criteria was the infliction of physical pain, but not necessarily any injury that amounted to minor or other types of harm to health. And the punishment was fine, community service, correction service, or arrest up to 45 days. And the final article for domestic violence in the first ever criminal code in Kazakhstan was Article 107 for torture or torment, otherwise called in Russian as istizania. And what it meant is that multiple cases of assault and battery that occurred at least 3 times in 1 year, they could be classified as this type of a crime. And the punishment again included fine, community service, correction service, or arrest up to 6 months or imprisonment for 2 years. This is also another important article for us to note, because I will offer you the statistics on this article, and you will see whether it's efficient and how often it is applied by courts. So in 2014, we adopted a new criminal code in Kazakhstan. And again, we had all the same 5 articles in the new code, but then there was an important difference. And an important difference, you can see them here. So for example, in the earlier code, all these 5 articles were considered as crimes. So they all, so what it meant is that if a person committed this type of a crime, then this type of crime would always appear on the criminal record of a person. So, so that was also quite an important point, and it meant that the person who would be brought to criminal proceedings for such crimes would always have this type of a note, a remark on the criminal record. But now in the new code of 2014, these two articles for minor harm to health and for assault and battery, they were transferred into the category of a criminal offense. And what it means is that for a criminal offense, there is a lighter punishment. So there is no imprisonment term. Maximum is an arrest for up to 45 days or 60 days. Also, there was a possibility of ordering an abuser such type of a punishment as performance of community service. But what is important is that a person who who was punished under a criminal offense would never get this remark on his or her criminal record. So that's the main difference. The crimes still continue to appear on the criminal record, while criminal offenses, they never appear on a criminal record. So that was a novelty in the new criminal code of 2014. And then we had a reform in 2017. And what happened is that we got new articles in our Code of Administrative Offenses. In the past, we already had an article for domestic violence, Article 73, which covers mainly psychological violence incidents. So as you may know, there are different types of violence, physical violence, sexual, economic, or psychological violence. Today, we would not be covering in detail these types of violence, but Article 73 basically included and covered psychological types of violence as a diminishing of members of the family, or ruining the furniture and so on, but without any physical contact with the victim of violence. And so we got two new articles, and these were the former articles in the criminal code, which were transferred to the administrative code. So minor harm to health became Article 73/1. And again, the criteria remained the same. The criteria remained as such as short-term health disorder under 21 days, but the punishment became much, much lighter. So, the punishment was only a fine of 15 monthly calculated indices, or arrest up to 15 days for the first time. And if this offense happened for the second time in the same within 12 months, then an abuser could get an arrest up to 20 days for the second time. And assault and battery also became an administrative offense. And the responsibility for this offense became a fine of 10 MCI, or arrest up to 15 days for the first time. And again, for the second time within the next 12 months, the punishment was an arrest up to 15 days. But then in January 2020, our Ministry of Interior decided that we need to make the punishment for these types of domestic violence even lighter. So they substituted fines with a court warning. And that's a very important point. The Ministry of Interior, they explained that why they decided to substitute fines with a court warning, because they believed that it was not good for families, because fines at the end were paid from the family budget, and they believe that they are doing something good for families because they could save money in their family budget, and they believe that a written court warning would be sufficient for a family abuser. But also, what I want to draw your attention to is that apart from court prosecution, administrative prosecution of abusers, in our legislation, we have a possibility for victims of domestic violence not to go to court, but ask for a protection order. So the protection order is not type of punishment, but it's again just a document, that is issued by the police, like участковый, a police or a local police officer, district police officer, and basically this protection order says that orders an abuser not to approach a member of the family who was subjected to domestic violence not to call, not to follow, not to stalk, not to consume alcohol or drugs, not to wear or not to buy guns or knives and so on. But again, the problem right now is that even if an abuser violates such a protection order, and this order is given for 30 days maximum, the punishment is again just a warning or an arrest up to 5 days. If a case reaches the court and the court issues, a warning or an arrest, the court also has a right to issue special court measures. And court measures can be issued up to 3 months. And in effect, they also contain the same requirements for an abuser, like not to approach, not to follow, not to commit domestic violence for the second time and so on. But again, in many cases, what we've seen is that abusers, they are not stopped by either protection orders or by special court measures. They again commit domestic violence against their family members, and the punishment for this is again quite light, just a fine of 5 MCI or arrest up to 7 days. And here what I want to note is that whenever we talk about an arrest up to 15 days, 20 days, or 7 days, in reality, abusers never get the full amount of all these days of arrest. Because according to the Ministry of Interior in Kazakhstan, we don't have sufficient facilities to keep arrested abusers and offenders. And for this reason, usually the courts, they give only 2 or maximum 3 days of arrest. So now let's talk about some arguments for decriminalization. So who were the main proponents of decriminalization? In the first place, and still, these are the Ministry of Interior, Prosecutor's General Office, and the Supreme Court. The main arguments that they put forward was that these crimes, these criminal offenses of assault and battery and infliction of minor harm to health, these were crimes of private prosecution. So in Kazakhstan, we need to understand that all crimes, they are categorized into 3 categories of private prosecution, public-private prosecution, and public prosecution. So the difference is that in cases of private prosecution, it means that police is not involved at all. The police does not help to collect evidence, to bring a case to court, and all burden of collecting evidence and prosecuting an offender lies with the victim of the crime. So basically what happened is that a woman who was battered by her husband, so for example, she had, to collect all the evidence, she had to go to the hospital to get all this forensic evidence that she has been beaten, and then she had to go to court to ensure that her husband would also appear in court, and so on. And of course, that was a lot of trouble, and many women, they decided not to pursue, this private prosecution way. And again, here we talk about societal issues and societal pressure from the family members, from the husband, because quite often, the family would put a lot of pressure on, for example, on the woman, and would say, why do you want to put the father of your children to prison? Think about it, because then your husband would always have this criminal record, this mark that he was brought to criminal liability, and this would spoil the future life of your children, because your children would not be able to get a good job, because whenever they would be applying, for example, for a work as police officers, there would be a very thorough background check run on their relatives as well, and if they see that their father served in an imprisonment term, they would never become police officers, and so on. So these were the kind of debates, these were the kind of arguments that were kind of brought to a woman, and to dissuade her from going to court. And unfortunately, these are the types of arguments that are brought forward today by the police and the Ministry of Interior in general, whenever we start discussion with them a possibility to criminalize the same types of offenses. But then again, if we talk about other arguments, is that because of this kind of concern about criminal liability and criminal record. In fact, there were quite low numbers of reported cases. So not that many women approached the police. And again, as I earlier said, there is really no separation between these types of offenses that were committed against general members of the public and against family members. So unfortunately, our state bodies of statistics, they do not, and they still do not give us this disaggregated data. And so, for example, whenever we got the statistics on the offenses of minor harm to health or assault and battery, we could not really see whether those offenses were committed against, for example, a neighbor or a passerby, any person in the street, or it was committed against members of the family. And the Ministry of Interior, they always cited as a positive example the statistics, the increase in newly reported cases after 2017. So here you can see this is the official statistics from the Ministry of Interior and the Supreme Court. For example, in 2016, according to Ministry of Interior, only 3,823 cases were reported of domestic violence, and only 678 cases were brought to court. Again, why the numbers are low, those that were actually prosecuted, it's because in private prosecution cases, it is allowed for parties to reconcile at any stage of investigation, either before court proceedings or even during court proceedings, and that's why there would be no order by the court issued, so no punishment would be given. So only 678 abuses were brought to court, whereas in 2018. Ministry of Interior is quite happy to say that already 9,700 cases were reported, 1,800 abuses, around these numbers were fined, and around 1,200 abuses were arrested. And for Article 73/2 for battery and assault, in 2016, courts they reported that they considered only 268 cases, whereas in 2018, courts considered already over 5,700 cases. So the increase you can see is quite dramatic, quite significant. So these were the main. These are the main arguments of our Supreme Court and law enforcement agencies. And if we talk about the arguments for criminalization, so the main proponents of criminalization are international organizations and NGOs, especially those NGOs who work with survivors of domestic violence. And they cite the following problems that they see in decriminalization. First of all, they claim that now, since the assault and battery and minor harm to health were transferred to administrative code, basically there is no criminal punishment for multiple incidents, for example, for violation of protection orders and special court measures for abusers. So basically what happens is that an abuser can beat his wife, for example, his wife or any family member 10, 20, 30 times a year. And the person would always get maximum an arrest of 2 days. And an abuser is not even stopped and deterred by protection orders or special measures by special court measures. And all these multiple incidents, they do not amount, they're not sufficient to prosecute an abuser under criminal code. And whenever we talk with the, and why it happens is it happens because for Article 110 to apply, which is an article for istizania, torment and torture, there should be at least 3 incidents of assault and battery or infliction of minor bodily harm that should happen within the same year. And and basically it means that a woman should wait and not report these 3 incidents, but she should wait and collect evidence, and only then she can go to police and apply, and make an application under this Article 110. But quite often it doesn't happen. It doesn't happen because Usually women, they don't wait for so long, they approach the police immediately. And if a person has been prosecuted under an administrative offense code, it means that a person cannot be punished twice for the same offense. So it means that if a person has served his administrative punishment in the form of a warning or in the form of an arrest, even though it can be only for 2 days, it means that this incident does not count anymore for it to fall under the criteria of Article 110 of the Criminal Code for torment. And again, this is quite an absurd article in my view, because basically it means that a woman should wait for at least 3 times to be battered. But we also know that there are many incidents when unfortunately an intimate partner can kill his wife even in the first incident or in the second incident. And that's why we can say that this is not really an efficient article, because according to the statistics in 2019, only two cases reached the court in the Republic of Kazakhstan. Another problem is that still, even under the administrative code of offenses, prosecution can be initiated only upon an application from a survivor of violence. So basically, that was a main problem in the criminal code, when a woman had to initiate everything herself and she would not apply because she didn't really see the point, or she feared the burden of collecting evidence and so on. And when decriminalization happened, the police officer, the Minister of Interior, said it actually would be very good, because then upon application from a woman, the police would do everything. They would be collecting evidence, they would be sending the case materials to court and so on. But again, we see this issue that all this investigation can be initiated only if there is an application from a survivor of violence. And we believe that this is again a problem, because even now, the family members, the intimate partner, they continue exercising a lot of pressure and intimidation of survivor of violence, again claiming, why do you want to create these problems? You are a bad woman if you want to bring your husband to court. Why you cannot resolve all your issues internally as a family issue, and so on. And that's why I will show the statistics a little bit later, but this is again one of the main reasons why we still have very, very few cases of domestic violence actually reaching the court. And again, whenever we discuss with the police, for example, why can't you change, this situation, for example, these modalities? Why don't you prosecute the abusers upon finding out about the facts of violence? Like, for example, in the traffic accidents and the, for example, road offenses. For example, if a person exceeds a speed limit or drives on a red light, the police does not wait for any application for any other person, to prosecute and fine this offender. So you only need to get the records from cameras and so on, or if you see it yourself, then you're fine. You don't wait for anyone to make an application. Why don't you do the same in the cases of domestic violence? But again, this is a question we currently discuss and debate on within our parliamentary working group on the development of the new law on prevention of domestic violence, and still we cannot find consensus and agreement with the police. So, and the problem again here is that for example, an adult, for example, can make such an application. But again, whenever we talk about children, little children aged 5, 6, 7 years who are abused by their parents, or whenever we talk about people with disabilities or elderly people, who are much physically weaker than abusers in the family, and who cannot, go and approach police and report about violence, I see that this big number of potential and actual survivors of domestic violence, they cannot actually get sufficient justice. And Then again, the problem remains that reconciliation is still available at any stage of prosecution under the administrative code. And again, under pressure, quite often survivors of violence, they just retrieve and withdraw their applications. The current punishment in the form of court warning is not adequate and proportionate to deter reoccurrence of violence. And basically what it means is that a husband, for example, any family member, for example, a husband or can break his wife's ribs, jaws, limbs, cause concussion, and if a woman does not stay in hospital for 21 days, then it is considered to be a minor harm to health, and an abuser gets only a warning from court. And as we know, usually our women, and especially if they have children, they would never stay in any hospital for 21 days because they understand that they need to continue taking care of their family members, and they just go back to home, and they still continue to work around the house with broken limbs, jaws, and so on. So, and of course, this does not deter the recurrence of such types of violence. Another concern and problem is that under the administrative code, the community service is not available as punishment. It's available only under the criminal code. And in my view, I believe that based on international, on the research of international practices, performance of community service is quite more adequate and efficient type of punishment for domestic abusers. Because again, if they wanted to use their physical force, why don't they do that in the form of performing community service, and helping society? But again, we see the resistance from the Ministry of Interior. They don't want to include this type of punishment within the administrative code of offenses. And at the same time, they don't want to return these articles to the criminal code for this type of punishment to be available. And finally, a little bit about the statistics to see how many cases we have so far. Unfortunately, during the COVID pandemic period, we have seen a 41% increase in domestic violence cases in Kazakhstan. For the first 8 months of 2020, 130,000 cases were reported, but again, only 25% of all cases were brought to court. And 40,000 protection orders were issued. So again, we see this problem that the majority of cases, they still remain latent. They are not even reported. And even those that are reported, at the end, aggressors, abusers, they face and enjoy impunity. And final points for discussion, which I think I would leave you with pondering about. I think whenever we talk about this debate of criminalization versus decriminalization, we always need to think about, who benefits from, for example, who benefited from decriminalization in our country. Of course, the police, the Ministry of Interior, they benefited the most, and not only the ministry, but the General Prosecutor's Office, the Supreme Court, they all benefited a lot. Because basically what happened is that because of the transfer and decriminalization of these types of crimes and criminal offenses, we have seen a decrease in the rates of crimes in Kazakhstan. So again, we see the decrease in criminal offenses and crimes at the expense of the most vulnerable members of our society. So we can say that we have much fewer criminal offenses being reported or prosecuted in our country. Whenever we talk about criminalization, again, we need to think who can benefit, from criminalization. Would it be the society or whoever, would benefit? Can we say that victims can benefit from criminalization because, if there is adequate, punishment, maybe again there would be much less crimes of domestic violence committed by abusers. But again, we all, as we discussed, quite often the victims of violence, they are concerned about, the future or for their husbands, especially under the societal pressure. And what do survivors of violence want? This is another question that we rarely ask our survivors about, and of course, no one marries, no one wants to form a family, no one thinks about, that at some point in their marriage, during their marriage, they may become victims of domestic violence, so this is another issue. And whichever research we may have had in Kazakhstan, I believe that this is an issue that has been widely significantly under-researched. And of course, we always need to think about other ways to prevent and deter domestic violence, because again, punishment, in my view, is not an efficient way to stop and prevent violence, but also decriminalization, as we have seen, does not deter any violence in Kazakhstan. And again, in my view, I think we need to invest more time, efforts, and budget in order to, approach the root causes of domestic violence. And of course, it's important to see what international experience says and how other countries deal with these issues. Again, here we see that in many countries, domestic violence is considered as a criminal offense. But again, we always need to take into account the context of our state as well. So thank you very much for your attention, dear participants. And I'm now ready to answer any questions you have.
Thank you very much, Khalida. Thank you for this very detailed presentation. And now we would like to open the Q&A session. Dear participants, if you have any questions or comments, please feel free to raise your hands. Or any questions? No, I don't know who is speaking, but. Is it okay to ask a question? Well, we can't hear you very well, I think. Can you speak a bit louder or? Can you hear me now? Not well. Khalida, can you hear?
Unfortunately, no, but if you could repeat, yes, I'll be happy to answer.
Okay. No, unfortunately. Maybe you leave your question in the chat room and I will read it, if it's okay, yeah? In the meantime, I have, a question because I think we've seen this kind of development in the kind of, on this topic, domestic violence in several neighboring countries in recent years, in parallel with Kazakhstan. I remember last year or 2 years ago in Russia, they had also this kind of decriminalization of domestic violence. And this year, if I remember, Kyrgyzstan had also updated their own kind of legislative stuff for domestic violence, but that was a bit different. And then for international kind of organizations, NGOs were saying that Kyrgyzstan now has the most kind of, the best, I would say, legislative basis for the protection of domestic violence. How do you think, is there a kind of synchronization of this different legislative kind of laws, or can we say about the trend in going on the post-Soviet space? Because as far as I remember, something happens in Russia, other countries in neighboring countries try to repeat it. So is this somehow connected to the situation in Russia?
Again, I think we may say that, again, some countries may follow one trend, others they follow another trend. Yes, indeed, in Russia, the very same articles of minor harm to health and assault and battery, they were decriminalized. And also, again, we see a lot of, outcry in society, from NGOs who work with victims of violence, that was wrong, and these articles should have remained in the criminal code. And but again, we always need to think from the perspective who benefits, from this decriminalization. Because, for example, I would like also to cite the example of Ukraine. Ukraine in 2017, they also adopted a new law on domestic violence, and it is a quite progressive law. And I would say that that law is the most progressive one and quite detailed in the area of post-Soviet states. And for example, in Ukraine, what they did is that they have an administrative liability for psychological violence. but for all physical types of violence, including assault and battery and minor harm to health, they still have them as criminal offenses. And again, when we talk about criminal offenses, we also always need to think about the punishment that is given, right, for these offenses. And these punishments should always be, adequate, proportionate, and the abuser should always understand, that he would not go away from justice, from punishment, that there would be no impunity. And I believe that should be also taken into account, so because, and again, whenever we talk about administrative offenses, for example, like what's the difference about administrative offenses and crimes? So basically, administrative law, it talks about administrative violations. They talk about violations of the public order, or it's kind of the offenses against the public interests and so on. But again, whenever we talk about assault and battery, when one person hits and beats up another person, we cannot really see here much, I would say, violation of public interest. In the first place, it is still a crime against a person. And that's why I believe, in my view, that for any crime against a person, there should be an adequate and proportionate punishment, and it should be a sort of, criminal punishment rather than just administrative. And we cannot, I would say, again, equate, for example, assault and battery with minor hooliganism, for example, or disturbance at night, violation of silence at night, or littering in public spaces, because we need to measure all these offenses according to their consequences for a victim of this offense. So, for example, if I see some litter, garbage in the street, which is, an administrative offense, it for me, the consequences are not really that serious, because yes, I will see that, I will not like it, but I will just go away and I will forget about this garbage, I will not remember about it the next day. But if unfortunately I'm beaten up by someone, and I'm told that this is also the same administrative offense, of course, for me, the consequences would be much graver, because I may be so much traumatized that I would be remembering about this beating, this assault for many, many years. So that's why I believe it's not really fair, to compare such offenses and have them in the same code.
Okay, thank you very much. We have a few questions here. The first one, have the criminal penalties for major and moderate harms remained the same, 7 years and 3 years respectively? The second question is, are there shelters for women who have suffered or experienced domestic violence when in Astana, in cities, in the regions as well, not big cities?
Yes, in the new code of 2014, these penalties for major and moderate harms, they indeed remain the same, up to 7 years and up to 3 years. So it may not be 7 years exactly, it may be 5, 4 years, and now usually the court gives much lower, amount of years, like for imprisonment, for example. But they remained, yes, in 2014 code, criminal code. And as for shelters, indeed, there are shelters for women, and right now, again, according to the Ministry of Interior, there are 40 shelters for women in Kazakhstan. But again, they're available only in the big cities. They're not available in rural areas, in smaller towns. And again, the problem is that they're not sufficient. They're not sufficient to accommodate all victims of domestic violence. But again, whenever we talk about shelters, there's also a difference of opinion to what extent we need to have these shelters. Because again, what happens is that quite often following a domestic violence incident, for some reason, it's not, for example, a man who usually leaves, the flat, the house, but it's usually a woman who is forced, to leave the house and find another accommodation. And I see here strong discrimination against women, because no one cares where a woman would go. No one cares where she would stay with her family, or with your parents, for example, or with your friends, neighbors, or she would find a shelter. No one cares. And again, whenever a woman leaves, she wants to save her life. And if there are little children, she cannot leave children at home. So children also have to move, to relocate from their flat, from their family house, and find another place to live. And again, this is another problem that may cause psychological trauma for children, because they have to go to a totally new environment, live in some new place, and no one really cares about women. But whenever we raise an issue that it should not be a woman who should leave the house, but it should be a man, an abuser, who should be restricted from entering the house, for example, for 10, 20 days and so on, as a form of kind of deterrence and punishment for him. We also face a lot of criticism that, oh, you are trying, what the man would do, he will become homeless, you don't care about him. So again, this is kind of these are the kinds of debates we have right now in society. But I believe shelters should be available, but kind of, yes, still for discussion.
Okay, there are kind of three questions from Gavin. I think they're very interesting, it seems. And the first one is there any research on police culture and in the policing of the domestic violence in Kazakhstan? The second question is, have there been any attempt to recruit more female police officers? Like in Georgia, and to a certain extent, like in Ukraine and like in Georgia. And finally, the rise, if you remember, the rise in the number of domestic violence from in 2008 and 2020, which was kind of 20 times higher, even more, I think. So is there any breakdown regionally, or where the greatest number of cases are being reported from?
Mm-hmm.
So this is three questions.
Yes, indeed, quite important questions to ask. The problem is that we don't really have much access to open, publicly available data from the Ministry of Interior. And actually, I can say that unfortunately, many of the decisions by the Ministry of Interior to decriminalize domestic violence, for example, in the first place, they were never grounded on any research. So unfortunately, this is a big issue across, the state governance in Kazakhstan, that many decisions, many decisions by the senior decision makers, they are made not because there is a real need, to adopt these decisions, but because, these decisions are motivated by material interests, self-interests of stakeholders and decision makers. So right now, but what I can say is that this year, new research was made about the service policing. So now there are some proposals, to reform the police and introduce a service police model in Kazakhstan as it exists in the UK, for example. And right now there is an ongoing pilot project. I believe it is implemented in Karaganda Oblast, and they're trying to see whether they can reform the police and make it kind of a service police in Kazakhstan. So yes, indeed, there is a problem with the research. And then regarding data, it's also very difficult to get data and even statistics on committed administrative offenses, because, for example, our committee on legal statistics of the General Prosecutor's Office, they give statistics only on crimes. And again, whenever we talk about crimes, they do not disaggregate the data and do not show any crimes in the domestic area. So the crimes of domestic violence, like moderate or grave harm to health. And again, they don't give any statistics on administrative offenses of assault and battery and minor harm to health. So the only way for us to get the statistics is to write an official, request to the relevant state bodies and ask them for this information, and then they would give this information upon the request. And then regarding the recruitment of police, female police officers, yes, we do have female police officers, and and since 2010, I would say we have departments of against violence against women and children in our police departments. But again, there is a major issue is that the quality of their work and whether they're trained and whether they get sufficient training, to deal with the survivors of domestic violence and so on. And unfortunately, we see here that that the number of these female officers is not sufficient, and unfortunately we also see that many of them they quit the job. They cannot it's difficult for them to work in this patriarchal system of policing in Kazakhstan.
Okay, thank you, Khalida. We have
just one more case. Yes, regarding the regional breakdown, unfortunately, we don't have it. The police never gives such details.
Okay, one more related question on the lack of data and lack of kind of research. So Fariza Birjan is asking whether there are kind of research groups or psychologists or sociologists working at the state level and researching this topic, maybe based on different under different agencies who purposefully work on this topic, research teams.
Yes. The thing is that the Ministry of Interior has its own research institute. Academy of Research of law enforcement agencies. The Prosecutor's General Office also has its research institute. But the problem is that all the research that is performed by these research institutes, it is not published. It is not published, and even if they write any research, for or against any legislation, it's not publicly available. And even if you ask for it, you will not be given. You may never get it, because, for example, for the last 9 months, I have been a member of the parliamentary working group. And we sit in the same working group, and we already had 20 sessions to discuss, the new bill on prevention of domestic violence. And representatives of the Ministry of Interior are also present in this working group. But even when we ask them to share, the statistics and so on, they do not do that. So quite often they just ignore our requests. The requests of NGOs and researchers. And for example, the statistics I just cited in my presentation about the number of reported cases and so on. Again, it's not very accurate statistics. Why? Because the police, they do not show how many of these incidents were recurring incidents. How many incidents were, committed after the protection orders were given. And whenever we ask the police to give us this disaggregated data by regions, by types of, by regions, and whether this was the first instance offense or a recurring offense, we still haven't received any data. So we can't say that there is sufficient cooperation between the civil society and our police
Hello, can I ask a question, please?
Yes, Aslan. Please.
Thank you very much. Thanks for Nazarbayev University organizing this, and thank you for Khalida finding a time. Just doing this good presentation, which is very accurate issue here in Kazakhstan. And just a few comments first about this research institutes and academy within a police and prosecutor office. I think it sounds a little bit, controversial. Funny that conflict of interest when they. I think there is no such practice in developed countries when the police, if you are doing a research on police services, how they can be under the police institution. Okay, that's just my emotional impression. My question to Khalida, I noticed that she has always got a very good expertise from cross-disciplinary point of view, law and sociology. Perhaps my question will be related more to sociological and research level. Khalida, how do you think among the researchers there is a camp who use a concept of victimization, the blaming of the victim, meaning that the research based on pacification countries where the domestic violence law is quite well developed. However, in a cultural level, there is a reporting was quite low due to the certain kind of the woman role and acceptance status of the wife in these Asian countries. How do you think, if we did a quite well law, do you think there could be a challenge in a cultural level in case of reporting from women's side?
Thank you for your question. Indeed, we cannot exclude such a possibility because we still live in a patriarchal society. And unfortunately, we have a very strong cultural victim blaming in our country, and not only for, survivors of domestic violence, but whenever we talk about, for example, any sexual violence case, it's always, a victim to be blamed. She was not dressed appropriately, she behaved provocatively, and so on. So that's why I absolutely agree that even if we have a fantastic law, well-developed law, but it goes without education, without sufficient education and changing the mentality of our population that, they should not, that victims should not be blamed, that it's only the aggressor, the abuser, who should be blamed, for committing violence in the first place, then of course we would, I agree that we may face this risk that underreporting would continue. So that's why I believe in order to tackle and prevent domestic violence, it's more efficient, to start with education. For example, Janibek, he mentioned my educational project, Street Law, and the main reason why I coordinate this project and what we do, we actually go to schools and we teach children about their human rights. We teach children that you have human rights, that no one can violate your rights to human dignity, to life, to all these sorts of rights, but also you have obligations also not to violate any other person's rights and human dignity, and you have a responsibility to respect the laws on human rights and so on. And why we do that is because we believe that we need to train and we need to change and put this kind of to educate our children to these universal human rights values, not to the patriarchal traditional values that they may see every day in their families. Because again, if a child grows up in a family where he sees violence every day, where a child is beaten up every day, where he sees some other family members being beaten up, and everyone tells him that it's okay, it's a norm, then this child grows up with this absolute confidence that this is a norm and this is how things are done, in my community, and why should I be different from them? And so this is a way, this is what I do in order to change, the perception of violence and the mentality of our community towards domestic violence and to any other type of violence. And we should not tolerate violence. We all should have a zero tolerance attitude towards any types of violence. We should not be afraid to report violence. And whenever we report, we should stand together with the victims of violence in order to push and force the police officers to prosecute and for courts to give adequate punishment for any type of violence against any person in our society.
Okay, I think we can allow 5 more minutes. We have 2 more questions here.
Okay.
Sorry, Iftikhar, we have 3 more questions. The first, I would like to give the floor to Altanay Bimbetova. Altanay, please, you can ask a question.
Thank you. Hello, everyone. My name is Altanay. I'm from medical school, public health. So this question is very, I would like to share my interest. And my question is it's known that entrepreneurs, they are obliged to recruit disabled people if their staff exceeds 25 persons. So is it possible to make a law who, like for manufacturers, for example, they have to shelter victims of violence and provide them a working place? Is it possible or not? I understand that there should be steps, that there should be like centers for victims. Then they have to go through proliferation, testing, everything. But is it possible to, for example, smoothen taxes for these manufacturers who can shelter a woman decided to start a new life? That's my question. Thank you.
Thank you very much, Altena. I believe it's a very interesting idea that should be proposed to our government. And actually, I support this idea. Why? Because we know that quite often victims and survivors of domestic violence, they have this dependency, psychological dependency, material dependency on their intimate partners. And quite often, this is the main reason why they return. You know, for example, because they can leave the house because, you know, what's actually this is also a problem with our shelters. For example, a woman would go to a shelter. She can stay in this shelter only up to 6 months. But again, the shelter is not helping the woman to find a job. You know, they're not, they don't have any negotiations with any entrepreneurs, you know, to give a job to this woman, you know, so it's still not a legal requirement. So we don't have any legal provisions for this. Whereas in Ukraine, for example, a woman, whenever she goes to a shelter, for example, by law, she's allowed to get like a small aid, monetary aid from the government, like maybe a minimum salary for 6 months, and then she's helped to acquire maybe a new profession, you know, she gets vocational training and she's helped to find a job. And all this is done in order to reduce her material and psychological dependency on her intimate partner. In our country, unfortunately, what is done by shelters is mainly only to give her like shelter, you know, a place to live, you know, somewhere safely. But all these measures in terms of finding a job and so on, they're not really, you know, well thought through at this moment. So that's why I believe it will be really a good idea, you know, to suggest, and this would indeed help victims of violence to build a new life, you know, and aggressors would also know that if they commit violence against their wives, for example, she would get this assistance, and maybe this would also force, you know, an abuser to correct his or her behavior and not to commit violence against their intimate partners. Thank you very much, Altunay. Very good idea.
And my question was inspired by Dom Mami. Have you heard about this?
Yes.
Mm-hmm. So pregnant women or women with children, they are offered to stay in this house for a year, and they are acquiring a new knowledge. They are working with psychologists, and they are acquiring new working profession. So, like, can we do this on a governmental level?
That's very good practice, and it's a volunteering practice, and I believe we should definitely change our standards of our state standards of assistance to victims of domestic violence. And actually, this is one of the reasons we have been discussing and developing a new law on prevention of domestic violence. Thank you very much. I'll bring this also to the attention of our members of the parliamentary working group. Thank you.
Okay, thank you. We have 2 more questions, and I just would like to combine those 2 questions. So the first one from Kanat Abdullah, he's asking, how can we compare Kazakhstan to other countries in terms of the number of cases of domestic violence, I guess. So where Kazakhstan is in this general picture. And the second question, maybe Iftihar, if you can address a question.
Yeah, thank you, Janibek, and thank you, Dr. Khalida. Very inspiring. My question is very simple. What do you think was the inspiration for Ministry of Interior to take this initiative? Was it cultural issues, or was it some kind of like self-interest, organizational self-interest?
In terms of decriminalization, you mean?
Yes,
to decriminalize? Yes. So regarding the first question, I would say that, you know, I haven't been comparing, you know, the amount of, I haven't compared the statistics of domestic violence cases across the region or with other countries. And I would say that maybe there's really little value in it. Why? Because even this number we currently have on 130,000 cases, this is not, you know, all, it's not accurate statistics. Again, because according to, because even the Ministry of Interior said the Minister of Interior in summer, he said that you need to multiply this number by 5. He said that out of 10 victims of domestic violence, only 2 people actually report the cases. Other 8 cases go underreported. So that's why, you know, we still cannot talk about accurate statistics of such cases. And again, in my view, yes, statistics is a good thing. But again, we should not wait, you know, for these statistics either to rise or to reduce. We need to prevent any type of violence. And even if we have only 1 case of violence, this is already a problem, and we need to react and address it effectively. And regarding the kind of the thinking behind of decriminalization by the Ministry of Interior, again, what I said, what I showed in my presentation, this is like the official position of the Ministry of Interior, because their official position was that we need to decriminalize because it would help police to prosecute domestic abusers, because when these cases were criminal types of offense, it meant, as I said, that the police was not involved. A victim had to collect all the evidence, go to court, and push for prosecution of the offender. And because it happened in the family, it was like many women, for example, intimate partners, they refused, you know, from prosecuting their husbands. And now and that's why, you know, the police believes that it's good that it was decriminalized. But again, in my view, the main reason why the police decided, you know, to decriminalize is to have less criminal offenses committed in the country. So basically, they wanted to improve the image of Kazakhstan, the reputation of Kazakhstan, that we don't have that many crimes of domestic violence and in general. And again, that's why I say that they basically did that at the expense of vulnerable members of family. And again, they consider domestic violence as a type of excession of speed limits and so on. So here I see that they're not really telling us the truth why they decriminalize. Because, for example, right now, what we suggest, we say, you can always criminalize the case, but you can again make these changes and change the category of the crime from being of private prosecution to make it into public prosecution. So you can do that, and again you can do the same thing. You know, whenever, for example, a woman reports assault and battery, the police gets involved and they collect the evidence, they send the materials to court and so on. But the police, they just don't want to have too much workload. So unfortunately, this is another issue which is not really openly told by our police officers.
Yeah, it's really unfortunate to hear this kind of things happening, let's say, in our country. Nevertheless, thank you very much, Khalida, for this interesting and super important topic and the presentation. So I hope that we will see some improvement in the future with the help of people like you and others kind of who are working on this important topic. And thank you others for joining. Yes.
May I just add one more thing? I see here a very good question from Tirza Pichota. What can we do practically to help new laws be passed to protect the abuse and to promote the value of life in society? This is actually a very pertinent question, because unfortunately right now, the new bill on prevention of domestic violence, which aims to filling all these gaps I mentioned today, it's under a very aggressive attack from a group of activists who claim that we don't need any new law, because this law would allow to arrest parents for 2 years if they just slap their children, or if parents do not buy a new iPhone to their children, they again would be imprisoned for 2 years and so on. And unfortunately, what we've seen is that right now this new bill was put on freeze. It was put on freeze because many state officials and members of parliament they got afraid. They now fear the cyberbullying against themselves and against the bill. And again, we see that there is an attack in order to cancel this law. And basically, it happens like in Russia. What happened in Russia last year, when there was a similar law in parliament, a similar bill in parliament, and eventually it was just canceled and dropped under the attack from different members of society. And again, there is nothing bad about expressing different points of view, but what's wrong is that the attackers, they use manipulative mechanisms. They spread fake news, fake information in order to create this wrong image about the bill. And again, they do not offer any other solution to help the victims of violence. So unfortunately right now, this bill, as I said, it could have been adopted in November, but now it's like it's been frozen. And again, I would really much appreciate if you, dear colleagues, would be raising this issue, or that we need to battle and combat the issue of domestic violence, and push and create this pressure on the authorities to do more to help the survivors of violence and to prevent domestic violence in the first place. Thank you very much.
Okay, thank you very much again. And thank you, dear participants, for joining us today. And I hope that you all have a great holiday season, despite the circumstances. And I will hope to see you next semester. Thank you very much and enjoy your evening. Thank you, Khalida.
Bye-bye. Thank you.
Thank you, Khalida.
Thank you very much.
You.
Thank you.
Khalida, пару вопросов, да, если можно?
Да, конечно, здесь.
Спасибо.